May it please the court, my name is Nurafika Bikichani, the senior counsel acting on behalf of the respondent, and beside me is Christina Patricia, my co-counsel for today. I'm afraid I'm not quite sure on the stand of the appellants, but on the case presented in the previous trial, I believe they would like to argue that the respondent has not established his case because he lacks the cause of action to bring the issue of breach before the High Court. Therefore, I submit to this honourable court that the respondent in our case have a valid cause of action to bring the issue of breach even though he is not a party under the two initial trusts based on several reasons. Firstly, the two initial trusts have been legally enforced in accordance with the law in Malaysia, subject to the initial agreement that it will form part of the final trust known as the Kimball Family Trust. I would like to clarify that the Kimball Family Trust shall consist three parts of the document, including the two initial trust deed and the Taqwa Trust, which has been only partly executed. Therefore, the appellant was trying to argue that the final trust does not exist because of its incomplete nature or incomplete instrument. However, my lady, I submit that regardless of the appellant's refusal to acknowledge the existence of this Taqwa Trust, subject to the initial agreement of these two initial trusts, there is no requirement which stated that the terms of this trust can only be enforced after the Taqwa Trust came into existence. Therefore, the appellant has the duty not to act in any manner inconsistent with the terms of the trust. Furthermore, the act of the appellant signing the two initial trusts suggested that she is committed to the creation of the final trust. Therefore, is sufficient to prove that final trust exists.
Okay, counsel. You are not allowed to refer to anything else.
Oh.
May I remind you?
Yeah.
Both the appellant and respondent did sign the initial trust, correct? Okay, but did she sign the Taqwa Trust?
She did not sign the Taqwa Trust. However, the Taqwa Trust is only meant to be a complementary document to the two initial trusts. It was only the purpose of this Taqwa Trust itself only to specify the details of distributing the property under the two initial trusts in accordance with the rightful grantor and beneficiaries as mandated under the two recitals of these two trusts.
Can you explain the two recitals that say so?
Under the recitals, it was provided that there are two grantor and 5 beneficiaries under the final trust. Therefore, it was never intended for the appellant to become the sole beneficiaries of the trust in the first place. Furthermore, based on, I believe that I have no longer rebuttal because the only thing that argued by the appellant just now is about the good arguable case. If it pleases the court, can I ask the court permission to submit with my own grounds? I submit to this court that the respondent has that the High Court of Malaysia has the jurisdiction to hear the case involving foreign parties and assets acquired outside of Malaysia due to the power granted under Section 23, Clause 1 of the CGA.
Counsel, did the appellant raise this issue just now?
No.
So why are you submitting on that?
Because the appellant only argue on that the respondent did not have any valid cause of action. I believe there is nothing that I can submit except that, and I already argued that the respondent has interest because he is a legal grantor under the final trust. Therefore, he has interest to bring the issue before the court, and therefore has established his case.
Okay, but if it's not being argued by the appellant, then why are you submitting on the issue of jurisdiction? That's my question.
Okay. Then I will proceed on the contention by the appellant that the respondent had not breached the journey trust in regards to the second appellant because the appellant has been appointed as a director of the company. Therefore, he has the authority to manage the company. However, if the court may refer to exhibit marked as TVKA under paragraph 7 until 9, it clearly indicates that such alia being one of the beneficiaries under the two initial trusts, has no knowledge in regards to the revocation letter, transfer of share and appointment of the director. Therefore,
Sir, this trust that you mentioned here are the two initial trusts, correct?
yes,
Okay. Reading both the account trust and joint trust shows that the defendant and defendant 2, defendant 1 and defendant 1 and defendant 2 are the beneficiaries.
yes.
So how does that give right to the respondent to query the issues under both trusts?
Because the essence of these two initial trusts itself was the creation of the final trust, which means it will form the subject matter of the final trust. In the final trust, the respondent is the legal grantor, and that he also has interest because the property under this trust consists of the respondent and the appellant joint property, which they had acquired in California and turned into a single property prior being held on trust.
Okay, what about the claim that the property was bought during the inheritance money from the appellant?
I believe the appellant has not submitted any evidence to support their contention. Also, if the court may refer to affidavit marked as DV10 or DV10, there is concerning marital property in California, which stated that the asset were to be held equally between the appellant and the respondent. Until there is no further modification by the parties, I believe that the court should treat that the property to be held jointly by the parties. Here, under paragraph 7 until 9, because Sech Alia has not given her informed consent in regards to the appointment of director, the appellant therefore had breached the terms of the trust, and since she is not, the appellant is not the sole beneficiaries under the trust, she has no better interest above the other beneficiaries, and therefore the revocation and the appointment shall become invalid. Therefore, I will now conclude on my submission that the ground for our initial claim is due to several losses suffered by the respondent due to the breach committed by the first appellant in regards to the two initial trusts, and it has nothing to do with the existence of the Taqwa trust itself. Therefore, the respondent has a valid cause of action to bring the issue before the case, and the appellant has failed to provide sufficient grounds to overturn the High Court decision. If there is no further question, I will end my submission now.